Hello, I'm Dr. Nagaratna, a faculty from National Law School of India University, Bangalore. Today I'm going to talk about one of the most vital topic of the criminal law, that is the substantive criminal law of our country, and that is the grounds of exceptions that are available to the offence of murder. Indeed an important topic because it is these grounds of exceptions provided under section 300 if proved makes an offence of murder an offence of culpable homicide, thereby bringing the accused under one of the ground of partial exemption, thereby making him get liable with lesser punishment compared to the one which he would have got under section 300 had these grounds of exceptions not been proved. Now the entire framework of Indian Penal Code when it comes to murder gets covered under sections 299 and 300. While 299 refers to culpable homicide not amounting to murder, is also considered as one of the general provision which covers within it culpable homicide amounting to murder as well as not amounting to murder. Hence you have few clauses which are commonly applicable for murder as well as culpable homicide not amounting to murder, which under English law is generally referred to as manslaughter. Now this offence of 299 gets converted into an offence of 300 provided one of the clause of section 300 is fulfilled with in terms of the conditions that these clauses provides for. Now once 299 becomes 300, that is culpable homicide becomes murder under 300, a court has to see if any one of the ground of exception that is provided under section 300 is fulfilled with or not, considering the situation or the circumstances of a case. If one of the 5 grounds provided by section 300 is fulfilled, the murder again becomes culpable homicide. Hence, it's an important topic which legally converts a case from murder to that of culpable homicide not amounting to murder. Now the whole object of this module that I am going to talk about is to see the possible ways of converting an offence of murder into culpable homicide, and these possible ways are nothing but these 5 grounds of exceptions that section 300 talks about. Now before that, going back to section 300, the very section 300 starts with the words saying except as otherwise provided, which means that this offence of 300 is subject to certain grounds of exceptions. On the other hand, section 300 says that culpable homicide amounts to murder if any one of the clauses that are mentioned under it is fulfilled with. It has 4 clauses, and the first refers to an act of killing somebody with an intention of killing that person. Being an offence with the clear intention of killing a person, it's considered as an offence of murder, and therefore it's generally referred to as culpable homicide amounting to murder. While the second one talks about committing an offence of murder with the intention of causing such bodily injury which the accused knows will result in death of that particular victim because of a specific condition or the circumstances to which that particular victim belongs to or is suffering from. Now again, because it's an offence which has a clear intention of causing death by way of causing that injury which he intends to cause, knowing that such injury would likely to cause the death of that particular victim, makes it a serious offence of culpable homicide amounting to murder. While the third clause of section 300 refers to a scenario where the accused has an intention of causing bodily injury of that nature which he knows will be enough to result in the death of the victim in the ordinary course of nature. The word used over here also includes sufficiency of that injury resulting in death, thereby again making the mens rea of the accused more clearer. The last clause of section 300 says that if a person commits an offence of murder by way of causing that imminently dangerous injury which he knows will in all probability result in death of the victim, is again committing an offence of murder. Now if any one of these 4 clauses mentioned in section 300 is present in a case scenario, the offence is generally considered as the offence of murder, that is culpable homicide amounting to murder. As earlier stated, the very section 300 begins with the use of the words except in cases hereinafter accepted culpable homicide is murder, which means that the entire section 300 is subject to 5 grounds of exceptions. Now, if this offence of murder, as narrated under section 300, comes under any one of the 5 grounds of exceptions again mentioned under 300, it would rather become a case of culpable homicide not amounting to murder, and it will no more remain to be an offence of murder. That means the accused comes under one of the partial ground of exemptions under which he would be punished for culpable homicide and not for murder. Let's now examine each of these 5 grounds of exceptions. Now, the first ground of exception says that culpable homicide is not murder if the offender, whilst deprived of the power of self-control by grave and sudden provocation, causes the death of the person who gave the provocation or causes death of any other person by mistake or accident. Now, that being the ground of exception makes it an offence of manslaughter or culpable homicide not amounting to murder, provided accused proves that the offence of murder was committed by him only because of the provocation that is received from the accused. And the nature of provocation that is considered as a ground of exception under this provision of the Indian Penal Code is that such provocation must be of grave and sudden in nature. Now, another condition that this ground of exception imposes is that the accused, whilst acting under the ground of provocation, is causing the death of the person who has caused that provocation or who has provoked him. Or if it is the death of any other person other than the one who has provoked him, it should be a case that should fall under an additional ground, and that is of either committing the offence by mistake or by accident. Otherwise, causing death of any other third party other than the one who is provoked or other than the one who gets killed while under provocation but because of mistake or accident, it shall not be a ground of exception unless these conditions are fulfilled with. Once this ground is fulfilled, the offence, as said earlier, becomes an offence of partial exemption, that is culpable homicide. Now, what is this provocation? Legally, IPC though doesn't define the term, there are quite a number of precedents that have clarified this term. Now, according to Justice Goddard, provocation is some act or a series of acts done by the dead man, that is the victim, towards the accused, which would cause in any reasonable man a sudden and temporary loss of self-control, making that person for the moment not a master of his mind. Thereby, merely acting under provocation, he might end up doing an act which would amount to an offence under the law. Now, the provocation, in order to be considered as a ground of exception for the offence of murder, must fulfill certain conditions, as was also reiterated by the first ground of exception to IPC as well as by various judicial decisions available under both English as well as under Indian law. Now, these conditions are: firstly, the provocation must be of sudden in nature and also grave in nature. Secondly, because of such provocation, the accused must lose his power of self-control. Now, these needs to be ascertained based on the examination of the facts of the cases. Thirdly, that the offence of murder was committed by that accused before he could cool down. That is, his whole act of committing the offence should be during that period when he has lost control because of provocation. Now, all these views were also expressed in a well-known Indian case called Nanavati versus State. Now, in this case, the court also refers to a statutory explanation provided to section 300's first ground of exception. Now, according to this first statutory explanation available to the ground of exception, it says, I quote, whether the provocation was sudden and grave enough to prevent the offence from amounting to murder is a question of fact. Now, this makes it the duty on the part of the court to ascertain from the facts of the case as to whether the provocation was the one which would make any other reasonable man lose his self-control and thereby qualify itself to be a ground of exception. Now, this needs to be ascertained by the court by applying the test of reasonable man. That which can provoke any other reasonable man, if provokes this accused in a given case, would certainly be considered as a ground of exception. Further, the ground of exception is itself subject to certain limitations that the Indian Penal Code puts for it. and those grounds of limitations subject to which the ground of provocation can be claimed as a ground of partial defense for murder are, firstly, that this provocation should not be sought by the accused voluntarily, or he shouldn't be doing an act which provokes the other person to do another thing and that thereby again provokes the accused to commit an offence. Hence, the provocation should not be the one which is voluntarily sought by the accused. Secondly, the provocation must not be given by anything done in obedience of the law or by a public servant who is lawfully exercising his power while discharging his duty as a public servant. Hence, this ground of exception is not available against a public servant or the one who is assisting a public servant while discharging his duty. Thirdly, that this provocation should not be given by anything done in the lawful exercise of right of self-defense. In fact, considering all these grounds makes it clear that any act done deliberately against a person or deliberately against a public servant or against a person who is exercising his right to self-defense would not qualify to be this ground of exemption. Thus, any act done under revenge can also not qualify to be a ground of provocation for the simple reason that acts done under revenge indicates premeditated plan of action, thereby indicating no loss of self-control or no loss of application of mind in a scenario. Now, the Supreme Court in Nanavati case further clarifies that the circumstances which induce a desire for revenge or a sudden passion of anger are not enough to come under this ground of exception. Indeed, circumstances which induce a desire for revenge are inconsistent with the provocation ground, since the cautious formulation of the desire for revenge means that the person has had time to think, to reflect, and that would itself negate the very application of this ground of defense, which purely applies in a case of sudden temporary loss of self-control. Provocation, therefore, refers to a scenario where a person is unable to think because of the provocation under which he is acting, because of the loss of thinking ability that he is suffering for that particular moment, temporarily at least. Provocation need not necessarily be confined to physical or verbal attack. It can also be something that depends upon the scenario that is built in surrounding the accused. Therefore, if the victim is creating a situation by not saying anything or by not doing anything, yet has created a situation that can provoke the accused to commit the offence, that can still come under this defense of provocation for the offence of murder. That is also clarified by the Supreme Court in KM Nanavati case. Now, that being the first ground of exception, let's move on to the second ground of exception available to the offence of murder. Now, the second ground of exception says that culpable homicide is not murder if the offender, in the exercise of his good faith of the right of private defense of person or property, exceeds the power given to him by law and causes the death of the person against whom he is exercising such right of defense without premeditation and without any intention of doing more harm than is necessary for the purpose of such defense. Now, the Indian Penal Code makes ground of self-defense on the whole as a ground of complete exemption from liability. That is, a complete ground of defense is something that Chapter 3 of the IPC provides for, provided certain conditions that this chapter puts in is fulfilled by the accused. That is, if the accused is acting in good faith while exercising his right of private defense and doesn't cross the limitations that the law provides for, he comes under the complete ground of exemption and his offence will not be treated as an offence. But there might be certain situations wherein an accused might cross those legal limitations, yet because he is acting while exercising his right of private defense and he is doing so in good faith without any mala fide exercise of his right of private defense, he would fall under this partial ground of exemption. Thus, this second ground of exemption to murder applies to a scenario which otherwise doesn't fall under the complete ground of exemption for the reason that the accused has crossed the legal limitations that the law provides for. He falls under this ground of partial exemption for the reason that he is still acting in good faith while exercising his right of private defense, either to defend his property or to defend his person. Now, in order to get this ground of exception, it is essential for the accused to prove that the act must be done in the exercise of his private defense of person or property, and then secondly, that the act done by him was purely under good faith without any mala fide intention. Thirdly, that the person doing the act must have exceeded his right given to him by the law, that is under chapter 3 of the IPC, and the act must have been done without any premeditation and without any intention of causing more harm than what was necessary under the ground of private defense. That refers to the principle of proportionality. Thus, an accused, while exercising his right of private defense in good faith, unfortunately crosses the legal limits imposed by the law of self-defense, that which is covered under the chapter on general exceptions, but falls under this scope of this ground of exception available to section 300. He gets this ground of partial defense instead of the complete defense from criminal liability, thereby making his offence an offence of culpable homicide and not that of murder. Coming to the third ground of exception to section 300. Now, this is a case wherein culpable homicide will not become murder if the offender, who is a public servant or is the one who is aiding the public servant, while acting for the advancement of public justice, exceeds the power given to him by the law and causes the death of that victim by doing an act which he in good faith believes to be lawful and necessary for the due discharge of his duty as a public servant, and without any ill will towards the person whose death is caused. Certain conditions that needs to be fulfilled by this ground are similar to the second ground of exemption to the offence of murder. That is, the accused should be acting completely with a bona fide intention without misusing the situation, and he is the one who is either a public servant or the one who is assisting a public servant, while exercising his rights and while discharging his duty under the lawful authority conferred upon him by the law, he ends up committing the offence of causing death of the victim. However, because his whole act is done without any mala fide intention, and whilst exercising his duty conferred upon him by the law, he gets this ground of partial exemption from criminal liability. While exercising his duty, in case he ends up committing the offence, criminal law gives him this immunity by conferring him this partial ground of exemption. Now, under general chapter that talks about the general exceptions to criminal liability, that is under IPC, any offence committed by a public servant under mistake of fact but with good faith and also within the legal limitations makes it an offence of complete exemption from criminal liability. But over here, this is a scenario wherein he is crossing his legal limitation, yet because he is acting in good faith, instead of falling under the ground of complete exemption, his case falls under the ground of partial exemption, thereby making it not an offence of murder, rather an offence of manslaughter, that is culpable homicide. Sometimes it is so that the accused, while exercising good faith, crosses the legal limitations that is conferred upon him by law, but because he has been acting in good faith, he gets this ground of exemption. This ground of exemption, however, can only be claimed by a public servant or a person who is assisting public servant while discharging his duty in advancement of public justice. Now, this defense protects this public servant or the one who is assisting him when they exceed the power conferred upon them by the law and thereby cause the death of the victim. And in order to come under this ground of exemption, it's essential that the accused proves that whatever he did was without any ill will or without any mala fide intention. In fact, we have a case which was the one in which a public servant gets this partial ground of exemption, and that is Dhaki Singh versus State, where a suspected thief who was arrested by a public servant while was trying to escape from jumping down from a train from its offside was shot by this constable who had apprehended him. Now, the only reason why he shoots at the victim was that he felt that he would otherwise lose the custody of that particular person. Now, the court over here sees this as a case of exceeding the legal authority that the law confers upon the public servant, but because he had no mala fide intention and committed the offence of murder only while exercising his legal duty, makes it an offence of culpable homicide not amounting to murder. Coming to the fourth ground of exception, the fourth ground of exception to section 300 says that culpable homicide is not murder if it is committed without premeditation in a sudden fight, in the heat of passion, upon a sudden quarrel, and without the offenders having taken undue advantage or acted in a cruel or unusual manner. An accused comes under this ground of exception when he commits murder during a sudden fight, again not being the one which is pre-planned by the parties to the fight, and this is something that is been done by the parties without any premeditation, that is, the accused had not pre-planned the offence or its commission, and that is also a case which would fall under this ground of exception provided accused also proves that he has not taken any undue advantage of the circumstances, and he should also prove that he acted in good faith, or rather without any cruel or unusual manner. Hence, the four conditions that needs to be fulfilled are that the accused acted during a sudden fight without any premeditation, without taking any undue advantage of the circumstances, and also without acting in any cruel or unusual manner. The provocation and this ground appears to be similar, but the ground of difference is that in a case of sudden fight, it would be very difficult to ascertain as to who provoked whom. It is possible that the parties to the fight would have provoked each other. That's the reason we have made this as a ground of separate exemption other than the ground of provocation. Now over here, it is essential to note that a case which technically may not fall under the first ground of exception can still fall under this ground of exception for the reason that these are the acts done under mutual provocation by the parties to a particular fight. It is essential to prove that the acts of the accused was not deliberate, was not mala fide, was not pre-planned, was not premeditated one. It's only when these conditions are fulfilled that an offence becomes manslaughter instead of murder. In fact, these are clarified in many number of cases by the court, including Mahesh Balmiki vs. State of Madhya Pradesh in 2001. Now, the Supreme Court of India has also clarified the scope of this particular provision in the case of Sandhya Jadhav by saying that this exception covers acts done in sudden fight, and the said exception deals with a case of prosecution not covered by the first ground of exception, after which its place would have been more appropriate. The exception is founded upon the same principle, for in both there is absence of premeditation, but while in the case of exception 1, there is total deprivation of self-control, and in the case of exception 4, there is only heat of passion under which a man loses his thinking ability and ends up committing the offence. There is provocation also in exception 4, as is there in exception 1, but the injury done is not the direct consequence of provocation under this fourth ground of exception. In fact, exception 4 deals with cases in which, notwithstanding that a blow may have been struck or some provocation given in the origin of the dispute or in whatever way the quarrel may have originated, yet the subsequent conduct of both the parties puts them in respect of the guilt upon equal footing. And this in fact justifies the very case to be brought down to the offence of manslaughter from that of murder. The court makes further clarification saying that the ground of sudden fight is nothing but a ground that implies mutual provocation and blows on each parties. However, it's essential to prove that nothing was done with a mala fide intention or with a premeditation or by misusing the circumstances of the case. Anything that is done under that sudden loss of temper by the accused because of sudden fight would fall under this ground of exception. Let's move on to the last ground of exception available to the offence of murder. That is, culpable homicide will not be murder when the person whose death is caused, being above the age of 18 years, suffers death or takes the risk of death with his own consent. Now, this refers to a case where the accused is causing the death of the victim, provided he is taking the consent of that victim, and additionally provided that the victim is the one who is above 18 years, makes this offence of death an offence of manslaughter or culpable homicide and not amounting to murder. Causing death with the consent of the victim is generally considered as a lesser serious offence than an offence of murder, because the motive over here need not necessarily be ill motive. Hence, this ground of exemption reduces the liability of the accused from that of murder to that of culpable homicide. The conditions that are to be proved over here, as said earlier, are that the victim is the one who has given the consent and the victim is the one who has crossed 18 years of age. Hence, in a case where the accused gets the consent of the victim, but because the victim is below 18 years of age, it doesn't make it a case of exception to murder and continues to be an offence of murder. It's however important to know and to prove that this consent should be an unconditional one without any reservations or preservations. Further, the consent given by the victim must be clear, express and an undoubted one. This whole burden lies upon the accused to get this ground of exemption. Consent of a person below 18 years would continue to make it an offence of murder. Now, cases of suicide pact where parties to the offence agree to end their life or help each other in ending their life with the consent of each other may come under this ground of exception if it technically doesn't fall under the ground of abetment to suicide. Similarly, cases of euthanasia may also fall under this ground of exception provided it's done with the consent of the victim. However, Supreme Court's clarifications in Aruna Shanbo case has put the case of euthanasia under a different standing today, but otherwise any offence of committing the death or causing the death with the consent of the victim would generally fall under this ground of exception provided conditions laid down under it are all fulfilled. Now, the liability for the offence of murder falling under these grounds of exceptions that I just said, that is, these 5 grounds of exceptions, let's see what shall be the extent of liability. As earlier mentioned, if an offence of culpable homicide falls under any one grounds or one clauses, that is out of the 4 clauses section 300 refers to, then culpable homicide becomes murder. That is, culpable homicide becomes murder provided one of the clause of section 300 is fulfilled out of the 4. Secondly, the same offence of murder can get back this situation or the status of culpable homicide not amounting to murder provided any one of the 5 grounds of exceptions are fulfilled with. Now, what is the consequence of bringing under any one of these grounds of exceptions? As earlier mentioned, this would make the case lesser serious than that of murder. This would make a case fall under the ground of partial exemption from criminal liability, for the reason that these are not the offences that are done with the extent of mens rea which is otherwise required under section 300. Cases such as that which falls under the ground of provocation or sudden fight indicates that an accused has lost his thinking ability at that particular point of time or had lost his self-control. Cases such as exceeding the authority that the law confers upon the public servant, or cases such as exceeding the limitations that the law confers upon a person who is exercising his right of private defense, would in fact make it a case of excusable defenses and also sometimes justificatory defenses for the reason that the motive behind the offence is not an ill motive act. So therefore, these, instead of falling under the complete ground of exemption because there are certain limitations that the accused has crossed, becomes the cases that falls under the partial ground of exemption for the reason that the accused still has good faith or has still committed an offence under this loss of self-control. While the last ground of exception, which refers to the act done with the consent of the victim, in fact is indicating a scenario wherein there might be no motive or ill motive behind the commission of the offences. Now, in the state of Uttar Pradesh versus R.S. Yadav, the Supreme Court in the year 1985 observed that except in cases covered by the 5th exception mentioned under section 300, culpable homicide is murder if the act is done with the intention of causing death or falls under any one of the clauses that section 300 refers to. This case makes it clear that 299 becomes 300 if one of the 4 clauses mentioned under 300 applies to a scenario. This case further clarifies that 300 can again become a case of culpable homicide provided one ground of exception, any one of the 5 grounds of exceptions mentioned under 300 applies to a case scenario. Now, what would have otherwise been a case that should have been punished under 302, that is section 302 of IPC, had it been a case of murder, will now get converted into an offence of culpable homicide not amounting to murder, and thereby it gets subjected to the application of section 304. Thus, murder, which is punishable under 302, becomes culpable homicide punishable under 304, provided any one of these grounds of exceptions are fulfilled with. Hence, you can see that there is a reduction in the liability that can be attached upon the accused for the reason that he is falling under these grounds of partial exemptions. Thus, in this whole module, we have seen how section 300 makes an offence a serious one provided any one of the clauses mentioned under it is fulfilled in a case of culpable homicide. Specifically, clause 1, 2, 3, 4 of 300, if is present in a case, then that case is generally referred to as culpable homicide amounting to murder. Secondly, if it is an offence of murder committed under any one of the 5 grounds of exceptions, the offence becomes culpable homicide, thereby getting punishment under section 304 instead of section 302. These are generally referred to as grounds of partial exemption for the reason that the accused is not getting completely immune from the criminal liability. He is not getting completely exempted from criminal liability. Rather, he is getting partial exemption from liability, and his punishment therefore would get reduced. So that's about the module on exceptions to murder.